Good morning, students. Students, good morning.
Morning.
Morning, ma'am.
Morning, ma'am.
Thank you for joining today's session where we will
Morning, madam.
Morning. Thank you for joining today's session where we will be talking about dissolution of a civil marriage, and we will be discussing divorce. And today's topic will be the grounds of divorce. Can I please ask that we mute ourselves? Bawini, please mute yourself. Please mute yourself. Can you please all remain muted until unless if you want to ask a question or you want to say something. So let's start. The grounds of divorce. There are 3 grounds of divorce in South Africa, which is irretrievable breakdown of a marriage, mental illness, and continuous unconsciousness. So can one of you explain to us, when we talk about irretrievable breakdown of a marriage, what are we talking about? Anyone? Students? Mukhawu, you can unmute yourself.
Good day, ma'am. How are you?
I'm fine, Mukhawu.
I'm good. So irretrievable marriage, to me, it means that, from the way I understand it, it means that there's no grounds for any restoration of the marriage, and then the relationship has been broken so that it cannot be restored.
Okay, thank you for that.
By far.
Okay, thank you for that. Nkosana?
Thank you, ma'am. My understanding in relation to irretrievable breakdown of a marriage is when the marriage has no reasonable prospects that it can be restored again, because of now the spouses, they are no longer enjoying that protection of communitas vita. So which means there is a period of a year that they are not staying together. They are separated, even if they are residing in the same house, but they are no longer talking to each other. So that is my understanding in relation to irretrievable breakdown.
Okay, thank you, Nkosana. Maria? Maria Iris? Okay. Okay, Maria? Okay, I'm gonna mute Maria. Mbulawa?
Can you hear me?
Yes, we can hear you, Mbulawa.
Yes, my understanding is that in a marriage, there has to be a mutual or mutuality of connecting. In other words, there must be seamless a mutual understanding between the two of you. If many of the things that connect you as a married couple do not come together, it comes to a point where then one by one of the most of the things that connect you get irretrievably broken down to an extent that it's not possible then to actually restore one or many of the pillars that connect you. You understand? For instance, if one of them, if there is no community, one of them could be when there is no sexual relations, which is the backbone of a marriage. Then it means your marriage is irretrievably broken down, because then there will be no prospect of such events, because the main purpose of getting into a marriage relationship is to have a mutual consent in most of the things that we do.
Okay, thank you so much, Mbulawa. Let's hear what Butali are. Butali?
Yes, good morning, madam.
Morning.
Yes, like other speakers have already covered some of the things. I think, in my view, irretrievable breakdown of marriage, entails, when marriage can no longer be restored to its normality. Thank you, ma'am.
Okay, thank you. Okay, when you talk about irretrievable breakdown of a marriage, most of you are correct. Is when a marriage has reached a state of disintegration that there is no reasonable prospect of a restoration of a normal marriage relationship between the two spouses. Now, can some of you give us, let me, Mutimbulawa, can some of you give us an example? In your prescribed textbook, they talk about 3 main factors of irretrievable breakdown of a marriage, but there are others. So can you tell me 3 main grounds that show that this marriage has irretrievably broken down? The first one of the students spoke about, that is the spouses are no longer living together as husband and wife. Can somebody give us one or the other 2, or even other examples when let's say a prospective client comes to your office and says, okay, I want to file for divorce. What questions, how would you know that the marriage has irretrievably broken down? What are some of the examples that shows that, for example, these parties or these spouses, their marriage is now over? Let me ask this question. If a prospective a client comes to you and says, my husband has impregnated his girlfriend, is that an example or a ground that shows that this marriage has irretrievably broken down? Let's hear what Somisa Vulani.
Yes, ma'am. I think that is the ground for divorce, because if I feel as the spouse that we cannot reconcile and work from that after there's been adultery or someone has cheated, if I feel as a spouse we cannot reconcile and work going forward, then it's grounds for divorce.
Okay, thank you for that. Nkosana?
Thank you, ma'am. I think firstly, I think your question is not quite clear on this issue, because one of the grounds is that, ma'am, if one of the spouses committed adultery, so it would depend on the issue of adultery, whether when this child was conceived, they were in a marriage at the time at this particular. That's number one issue that it needs to be clear. But the other grounds is that there should be malicious desertion, and then there should be mental insanity, which constitutes the grounds for divorce. So that is my understanding, ma'am.
Okay, thank you. Let's say Mpulawa, is your hand up? Mpulawa?
My hand is not up.
Okay. If your hand is not up, please remove your hand so that we can see who's raising their hands and who's not raising their hands. Nkosana, thank you for that. But can I say that mental illness is another ground for divorce, but it does not form part of an irretrievable breakdown of a marriage. There are 3 grounds under irretrievable breakdown of a marriage. Firstly, the parties have not lived together as husband and wife for a continuous period of at least 1 year prior to the institution or filing of divorce. Secondly, the defendant or one of the spouses have committed adultery and the other spouse finds it difficult to continue with the marriage relationship. And the third one is the defendant or one of the spouse is a habitual criminal and their spouse finds it difficult to continue with their marriage relationship, or they have been imprisoned. But these are just examples. There are others. So my question now to you is, let's say a client comes to you and says, I've been married with this man for 2 years now, and then in the 2 years, although we are not fighting, although there is no adultery, I'm just not feeling this person. I am not in love with this person, and I want out of this marriage. Would you say this is also a ground of, this is also, let me just mute Ngulawa. Would you say this is also a ground for irretrievable breakdown of a marriage if a spouse's reason are just that I don't love this spouse anymore and I want out? Is not loving a person or not loving your spouse a good reason to file for divorce? Let's hear what Ethel is saying. Ethel? Ethel?
Hello.
Ethel? Hello, Ethel?
Yes, ma'am. Good morning. Yes,
Morning.
that is one of the reasons that can make court to consider granting divorce if one spouse is no more longer in love with another spouse. But if they have married, you married a person knowing that you are not in love with that person, then that is another way, that is another story, because you knew before you marry this person that you don't love this person. It might not be a good a reason for marriage, for divorce, the grounds for divorce. But if you have married, you have discovered in the marriage that you are no more longer loving this person because of other reasons that might happen. Maybe there's no satisfaction of conjugal rights. The person is not like the companionship, the affection, the comfort, the mutual services is no more longer there. Maybe that is when you realize, no, this person, I don't love this person anymore because of these reasons. That is another example of ground for divorce.
Okay, thank you so much. Let's hear what Ethel. Ethel, is your hand up?
No, I'm the one who just spoke.
Okay,
yes.
Thank you. JC? 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 Okay, JC has put down his or her hand. Nkosana, is your hand up?
Yes, ma'am. I just want to augment to what my fellow colleague was saying. She's quite spot on that issue, that adultery on this issue, it's one of the grounds which the court may institute an order for the divorce. And also to add on that, as I've indicated earlier, that there could be no marriage if there is no communitas. So it's one of the things. If we are no longer happy, which means that there's no longer love in that is a marriage. So it's one of the things that the court might also consider in making that order. So I just wanted to add that.
Okay, thank you so much. On the issue of a spouse not loving their partner or their spouse, once a spouse says, I no longer love or I'm no longer in love with my spouse and I don't want to continue with the marriage, whether they got married not really loving their spouse, it's going to be difficult to prove that. But what our law says is nobody can be forced to be in a marriage that they don't want to be part of. Because of that, by just saying I am no longer in love with my spouse and I do not want to continue with this marriage, that is a good ground that shows that this marriage has irretrievably broken down. If, however, there is a possibility that through marriage counseling, the marriage can be saved, the court has the discretion to say, okay, let's postpone the proceedings so that you, the spouses, can go and attend marriage counseling and see if maybe the marriage can be saved. But if the marriage cannot be saved, then the divorce will be granted. Brinsby, I see your hand is up. Brinsby?
Yes, good morning. Sorry, I was trying to
Morning.
mute. Yes. I got all the reasons that people are saying, but there's one thing that I just want to ask. We currently seeing a situation of men who target women who are resourceful, and they continuously engage in a relationship, then immediately go into a marriage, and a few years down the line they get divorced. Do they also, does the law look at the man that how many times has he divorced money for the sake of getting resources out of this woman? Thanks.
Okay, for that, it's going to be difficult for the government to actually track that, because divorce is the department which is responsible for termination of the marriages is the Department of Justice, and the Department of Home Affairs is responsible for registration of marriages. So the two departments, although they work together, they also don't work together in such a manner that it is easy to pick up that John got divorced this week, and 2 weeks later or 2 months later, John is now getting married. The situation now is such that spouses who file for divorce, once they get their divorce decree, they need to go themselves to the Department of Home Affairs to present the divorce decree so that the Home Affairs changes their status. Unlike before, where the system, where the Department of Justice will send the information to the Department of Home Affairs, because of various circumstances, is now becoming difficult for Department of Home Affairs to know that, okay, now on the system, this one whose status is married is now unmarried. So there is really nothing the government can do about men or women who keep on getting married, divorcing, getting married and divorced, because there is no law which says how many times you're supposed to get married or how many times you're supposed to get a divorce. And the other challenge is that how will you prove that this individual they are getting married solely for the purpose of benefiting from their spouse? It can happen that they get married and the marriage unfortunately does not work out, and because they don't believe in staying in unhappy situations, they just file for divorce, move to the next one, and because they also believe in marriage, they marry the next person. So those who have been victims, unfortunately for them, those who have succeeded in enriching themselves through getting married and divorcing, I guess is working for them now. And yeah, that's it. But it is very, very difficult to actually prove that a person is only getting married to enrich themselves, and not necessarily they have the intention of entering into a valid marriage relationship. Thank you for that. Let's hear who asked the question. Was it Lisa? No, Lisa.
Yes, ma'am. So I
Yes.
wanted to ask a question just in relation to what Ethel said. I think that's her name. Regarding falling out of love, getting into a relationship, and then into a marriage rather, and then knowing that you are not in love with the person, and then she also mentioned something about how if you have prior knowledge of not being in love with this person, it might be difficult to file for divorce. However, if you fall out of love with the person during the course of the marriage, then the court can grant it. So now my question is in relation to people that are in arranged marriages. So is that automatically, or can we say that is automatically ground enough for someone to say, well, this person did not decide to marry this man or this woman. They were forced into it, or they were coerced into it, whatever the situation might have been, by families, and they were never in love with the person, so hence they want to divorce.
Okay, firstly, remember, in order to enter into a valid, recognized civil marriage, there are requirements that you must comply with. So let's assume that in this arranged marriage, which was done, let's say it was done through the church, all the requirements were complied with, and let's say it's the wife. The wife says, when asked, do you volunteer to enter into this marriage? And then they said yes. Although it is an arranged marriage, because they voluntarily entered into it, they cannot now argue that I was forced, because by saying I was forced, then that is going to be a ground for declaring that marriage null and void on the ground that you were coerced, you entered into it under duress. You understand? So
Yes.
by just saying, okay, maybe I was not in love, but I thought that upon us getting married, love was going to grow and we were going to have a normal relationship. So they can argue that, okay, unfortunately, that love did not develop. Because of that, I want out of this marriage. So yes, it is a ground that I am not in love with this person, because what I thought was going to happen, it did not happen.
Oh, okay. Thank you very much, ma'am. I understand. Thank you.
Thank you so much. The next one, can we hear from Nosi Piwe? Nosi Piwe?
It's actually a follow-up question on the possibility of a marriage counseling. So to ask in terms of, does it give like a period to say, or does it depend on case by case to say we're giving 6 months or 3 months? Is that stipulated anyway in terms of the duration?
Students, can you hear me?
Yes, ma'am.
Yes,
Hello?
we can.
Okay,
Yes,
I'm
ma'am.
sorry about that.
Yes,
So I was
ma'am.
not,
Yeah, we can.
okay, I was not hearing anybody. Okay, Sam, your hand is up.
Sorry, my question wasn't answered.
It wasn't answered, or it was answered?
No, it wasn't.
Okay, please repeat your question.
I was asking with regards to the possibility of the marriage counseling being on the cards. Is there a duration, for example, to say from the court perspective, to say we're giving you 6 months or 3 months to work it out, or does it depend on a case by case?
No, it depends on a case by case, but there is no duration. So normally what the court will do is will just postpone the matter. In other instances, they will give another date for the parties to come to court. In other instances, they will not give a date. They will just inform the parties that, okay, you can return if you have, you return and apply for a new court date if the marriage counseling did not work.
Okay. No, thank you very much.
Okay. Godfrey? Godfrey? Godfrey?
This is Sam, ma'am.
Okay, Sam, you can talk.
Yeah, ma'am. Since divorce is encompassed with the clean break principle envisaged in the Divorce Act, my question is, you spoke of marriage counseling. In order for a court to dissolve the marriage bond, what does the court look at in respect to divorce?
The court looks at whether has the marriage irretrievably broken down, which is what we are talking about now. We are talking about examples which you can show to the court that my client's marriage has irretrievably broken down because the parties have not lived together. There has been adultery. One of the parties, both of them, are no longer in love with each other, and they are both in agreement that it is not in the best interest of both of them that they continue with this marriage relationship.
Yes.
So that is one of the reasons. We are going to talk about the other two reasons that we can show in court that the marriage the divorce must be granted.
Okay. So another question would be, if both parties who are in a divorce proceedings have not went under counseling, and they deem not see a need to go through counseling, will still the court grant a divorce order, or will the court ask if maybe have they taken steps in order to save their marriage or not?
Okay, it is not a legal requirement that the spouses must go for marriage counseling. It is advisable, and the parties can state that they do not see that even if they go for marriage counseling, the marriage relationship will be saved.
Yeah, I'm asking this question because I once went to a sitting in a high court around where I live, and then the judge asked a question to the plaintiff if they have acquired marriage counseling, and the response of the plaintiff was no, they have not. And then the court says, but the court is not satisfied that this marriage has irretrievably broken down.
Yes.
Even though it is not a legal, it is not a requirement that there should be a report of a report of a marriage counselor to be filed together with divorce papers and all documents in order for the court to give to dissolve the marriage bond.
Yeah, okay. In your example, the problem now is, okay, just hold on. I just want to mute. Okay, I'm gonna mute everybody. Okay. In the example that you have just given, the grounds that the parties stated in their pleadings, the court was not satisfied. This is the reason why the presiding officer said, I am not convinced that the marriage has irretrievably broken down. So
correct.
The presiding officer did not say, but you have to go for marriage counseling. He just said, you have not convinced me. So it depends on what they had said that led to the presiding officer not to be convinced that, you know what. So the presiding officer, based on what was happening, reached a conclusion that there is a possibility that this marriage can be saved, although the presiding officer cannot give an order that to go for marriage counseling.
No, it's clear.
Okay, thank you. Moraba?
Yes,
Moraba? Okay.
Yes, ma'am.
Yes, you can talk, Moraba.
Good morning, everyone.
Morning,
I
Moraba.
want to ask if the marriage counseling is the responsibility of the court or the government.
Okay, what do you mean the responsibility of the court or the government? Are you talking in terms of payment, in terms of providing service? What do you mean?
In terms of payment and providing the services.
Okay, it is the responsibility of the parties to arrange their own marriage counseling, but there are government institutions that provide free marriage counseling. For example, I know that the Department of Social Development does assist for spouses who do not have the means to pay a private counselor or a private marriage counselor. So it is not necessarily the duty of the government. It is definitely not the duty of the court, because the court only deals with legal matters. And marriage counseling is for trying to save the marriage, and not necessarily a part and parcel of court services.
Thank you, ma'am.
Okay, can we have Liberty? Liberty? Morning, Liberty.
Yes. Okay, I wanted to ask with regards to, I understand that into the Divorce Act 70 of 1929, I think there is the no fault system that applies to our divorce law.
Yes.
So with adultery, isn't it since the court has the discretion to grant a divorce, is it I wanted to say, is it possible that they'll only consider adultery more as evidence that you can present before the court, and let's say the divorce matter is opposed by let's say the defendant? Is it possible that the court can choose not to grant it? Let's say it's opposed.
Okay.
Because adultery is not a ground for divorce, but it is evidence that you can present before the court.
Yeah. Okay. Thank you for that question. Firstly, the court's discretion to grant or to refuse to grant a divorce. Through case legislation, it has been confirmed that the court does not necessarily have the discretion to refuse to grant a divorce, with the exception of Section 5A of the Divorce Act. There are three important cases that you must know when it comes to the court's discretion to refuse a divorce. And the two most important cases are Levy versus Levy and Schwartz, that is SCHWARTZ, where the Supreme Court of Appeal, in an obiter dictum, said that, or expressed the view that the court do not have a discretion, and that the divorce must be granted once it has been proven that the marriage has irretrievably broken down. So if a spouse proves that my husband or my wife committed adultery, and I do not want to continue with this marriage, as a result, the court has no choice but to grant the divorce. The exception with the court's powers to refuse to grant a divorce is with Section 5A, A, where the spouses are married in terms of civil, the Marriage Act, but also got married in terms of religious right, where in terms of the religious right, there are certain processes that must be followed in order for the marriage to also be terminated in terms of their religious belief. So if, let's say, in terms of the Divorce Act, the court can terminate the marriage, but in terms of the religious rights, that marriage will still not be terminated until there are certain steps that the spouses must follow. The court then has the discretion of saying you must firstly follow those steps, so that when we terminate the marriage from the civil, when we terminate the civil marriage, automatically even the religious marriage will be terminated. So it is for the purpose of your studies, it is very important to note that the court does not necessarily have a discretion to refuse to terminate the marriage, with the exception of Section 5, capital A. Do you understand, Liberty? Have I answered you?
Yes, ma'am.
Okay, thank you. Can we hear from Doe? 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 Doug? Doe, can you hear us? Okay, let's check others. Can we hear from Somisa? Is your hand up again?
Yes,
Somisa?
ma'am.
Okay, you can
Yes,
ask.
ma'am. I wanted to ask, what if one of the parties does not want to sign the divorce papers? And also, what if is it possible for me to get divorced and then also marry the same partner later on lawfully? Is it allowed?
Okay, let me start with the second question. It is allowed because there is no law prohibiting ex-spouses from getting married to each other again. Your first question, if your this goes to okay, if your spouse refuses to accept the divorce summons can only be served by a sheriff of court. If your spouse refuses to accept the divorce summons, and then you tried by other means, let's say the attorneys, as an attorney, you try to send an email to the defendant, and a family member, say, of your client also tried to speak with the defendant, and then the sheriff at least must go, must firstly go first time, and must also attempt again to go. If the defendant is still not cooperating, you and your client can bring a court application requesting permission to serve the divorce summons using other means. Previously, the means, this process is called substituted divorce. Previously, the means will be to say to have the divorce summons published in the newspaper. But these days, the court does grant permission for the summons to be served by way of email or to be served by way of WhatsApp. But for the court to give that order, you must prove to the court that you attempted to serve personally, because the divorce summons must be served personally, but the defendant was not cooperating, and you had no choice but to approach the court to request an order that the summons be served using other means. Do you understand?
So
that's
then
how.
what if, yes, ma'am.
Okay,
what if the person still doesn't want to sign because maybe they are scared, maybe we are married in community of property and they're actually worried that now we're going to have to split property, and they just don't want to get divorced because of the consequences of divorce.
Okay, that's what I'm saying. If the court gives an order that you can serve via email, they don't have to sign anything. You have to send them by email and have proof. So in most of their emails, you will do that report where it says, you must receive the sent report, and then also maybe receive the read report. If you have been granted permission to serve by email, you just need to prove to the court that the email was sent on this day. So the reason why there is substituted divorce service is to also accommodate those situations where the spouse or the defendant refuses to sign the divorce summons. And that is good enough, as long as you have proven to the court that there is no other way of saving the summons because the defendant is not cooperating. There is a good possibility or a good chance that the court will grant an order that serve the summons through email. Whether he's going to open the email, that is no longer a problem of the plaintiff. You and your client is no longer your problem, as long as you can prove that you have followed the court order. Do you understand?
Thank you so much, ma'am.
Okay.
Ma'am, following that question, sorry to this Sam.
Okay, Sam.
Following that question, I'm clear on what you just explained. Following that question, can a divorce order be rescinded, and if not, why?
Yes, a divorce order can be rescinded, for example, if it was obtained fraudulently, or most of the time, if it was obtained fraudulently, or if the defendant, for whatever good reasons, that they can convince the court that we need to rescind this court judgment. But most of the time, if the process was followed, the correct process was followed to the T, it is often very unlikely that the court will rescind the divorce order. But your answer is yes, it can be rescinded.
Wouldn't it change the state? Is the court inclined to change the status of parties?
What do you mean change the status of parties?
Remember those parties were now divorced. Now, if it rescinds, it takes back the parties to be married.
Yes, that is
isn't the right route a variation, not a rescission?
Remember, if the court order is rescinded, you are taken back to your position before there was a court order, and then the process will start again. It does not necessarily mean that the spouses must now continue with their marriage relationship, but the reason why the order was rescinded because of a default that is in such a manner that the court had no choice but to say, let's rescind this judgment so that the process starts again. As I said, a good example is when a divorce was fraudulently obtained. And a divorce is usually fraudulently obtained through substituted service, where a spouse will lie, the plaintiff will lie to the court and say, I do not know the whereabouts of my spouse, of the defendant. And once the order has been granted and the defendant becomes aware, as long as they can prove that their whereabouts were always known and it was never brought to their attention that a divorce process was being instituted, the sheriff never came to them, then that one will have to be rescinded. Okay.
Oh, no, I understand.
Okay. Thank you. Can we hear from? Okay. Let's start. Mbulawa, is your hand up? Mbulawa? Okay, let's move. Somisa? Okay. No. Okay, who's speaking?
I just didn't put my hand down.
Okay.
Nomsa?
I just didn't put my hand down. Okay, it's fine. It's fine. Nomsa?
Hello.
Your hand up. Nomsa? Okay, morning.
Yes, it's me. Morning. My question is, I want to know, does marrying a person under false pretenses constitute an irretrievable breakdown of the marriage?
Okay, it can be an irretrievable breakdown.
For example, if A were to marry B on the reason that B is pregnant.
Okay.
And later on find out that B is not pregnant.
Okay, that one can go to the validity of a marriage. You can bring a court application to have the marriage declared null and void, so that its status is going to be as if it never existed from the start. And your reason is because there was a misrepresentation. So remember, there is a difference between bringing a court application to have the marriage declared null and void and bringing a court application for a divorce. Bringing a court application to have the marriage declared null and void, the result it will be that the marriage never existed from the onset, and there is not going to be sharing of any assets. Let's say the parties were married in common of property, but if you are bringing a court application for termination of a marriage through divorce, then there's going to be the matrimonial consequences of a divorce, sharing if you are married in terms 50-50, sharing if you are married in common of property, or accrual calculation, and that we're going to talk about when we talk about the consequences of a divorce.
Okay, thank you.
Okay, thank you. Moraba? Moraba?
My hand is down, ma'am.
Okay, Nkosana? Nkosana, is your hand up?
Yes, it's up, ma'am.
Okay.
Ma'am, let me first thank you for the explanation that we have provided us. I just need, I think you have crystallized your position in relation to the powers of the court, which their powers are vested on Section 5. So I do understand that one. So I just want us to go to the guidelines of Section 4.2, 4.2b. Just want to ascertain, ma'am, the approach of the court as to how do they deal with a situation whereby one of the spouses has committed adultery, and then there is no evidence, there is no collection of evidence to be provided before the court. And myself, the other spouse as a defendant, is going to the court on a continuous basis to go and defend his position to say, I've never committed any adultery. So how is the court, what is the application of the court in obtaining evidence based on the hearsay? Because I would assume in most of the cases when there is adultery, let's leave the issue that there was a child that was conceived because of the other spouses has ventured into a relationship and then there was a child. Let's assume there's no child. I was involved in adultery, and then I just want to check the approach of the court and also taking Section 4.2a in cognizance of this statement, because now such things, they might constitute a lack of consortium because of now the other spouse is no longer interested in sleeping with the partner, so there is no longer that compassionate. Maybe then I just want to ascertain whether the consortium, it can be the proof to say we're no longer sleeping together because of the other one, and it has been a duration of a certain time that we're not sleeping together. So the court might take that as a basis that there was adultery, that it was committed in that regard. So I just want clarity in that now. I think you've understand my question.
Yeah. Okay, thank you for your question. Okay, when it comes to adultery, and then it's this one is saying yes, you had an affair, and the other spouse is saying no, I did not have an affair. Although they can, let's say there is no proof of that, the court's responsibility or the court's duty is firstly to ensure that this marriage has irretrievably broken down. So if the plaintiff cannot prove that there was adultery, now the question is, based on other things, for example, can this marriage continue with this allegation? Has trust been lost? Because when it comes to the issue of adultery and accusations, there's also the issue of trust. The question now is, has the marriage reached such a state that the parties can continue? Has the marriage reached such a state that the parties can live together as husband and wife? Remember, I said that in law, no person can be forced to be in a marriage that they do not want to be part of. Let's say the plaintiff is unable to prove that there was indeed adultery, but they are able to prove that, the marriage or the situation between me and my husband, or between the husband and the wife, it is now in such a manner that even if there was no adultery, these two spouses will not be able to have a normal relationship because the trust has been broken, communication has been broken. So to prove the irretrievable breakdown ground, there is a whole list of them. Just by saying I do not longer want to continue with this marriage because I no longer trust this person, even if we can go for marriage counseling, I don't think anything will change. That alone is a good ground for saying, you know what, the marriage has now failed. So the key words are the marriage has reached such a state that it cannot, or it will not go back to the normal marriage relationship. So the question that you must ask is, will these two parties have a normal marriage relationship? If the answer is yes, then the court can say, okay, let's postpone the matter so that you try and fix your marriage. If the answer is no, even if the accusations of adultery were not proven, then the plaintiff would have succeeded because they have shown the court that there is no, or there can never be a normal marriage relationship between me and my spouse. Do you understand, Nkosana? Nkosana, unmute yourself.
Yes, I do understand you quite clear, ma'am. Just that I'm worried. I've asked this question intentionally because now it appears that the court is taking the plaintiff approach more than of a defendant in this regard. Because now if the one would come and allege, despite that there is no prima facie evidence, then the gratitude will be given to that person who has come to make such a claim, then it's becoming a worrying matter. But I've understood your position, ma'am, because at times people might enter in a marriage because of they want particular interest in that, and then if now they are going to go in court and say no, I'm no longer happy, then there is no appetite by the court to try and establish some certain mechanism to try and remedy, then it's a problem. But I understood your position, ma'am.
Okay, what is important to note is that no adult can be forced, or no person can be forced to continue with a marriage that they no longer want to be part of. So this is the biggest challenge that the court is facing. Even if the court can say, okay, you really were not able to convince or to prove that this marriage has irretrievably broken down. But now the question is, do we say because you did not prove the ground for divorce, go back and go back to your spouse and continue with your marriage, even if you have showed or you have informed us that I do not want to continue with this marriage? So that is where now the problem is. And that is why the court these days, once we are out of lockdown, when you have a chance, just go and attend one of the divorce matters in any court. Then you will see the challenges that the presiding officers are usually faced with, because they cannot force a person. Yes, they do postpone matters, but most of the time matters are postponed, and then they usually say to the parties, go and further discuss how you're going to divide your matrimonial estate. But they really postpone a matter because they believe that the marriage can be saved unless the two spouses themselves, the two parties, agree that, okay, let's go, we are gonna go back and seek marriage counseling and try and make this marriage work. Okay, thank you for that. Let's hear from. Okay, thank you, Nkosana. Let's hear from Binelo. Buinelo. Okay, let's move. Let's hear from Cynthia. Cynthia.
Yes, I'm sorry. Hi, sorry.
Okay.
I was meeting myself. Ma'am, I actually just wanted you to explain the subjective and the objective approach that the court uses. I did read, but I didn't actually understand how like it's put into action to say, okay, the subjective approach was used here and the objective approach was used. What I did get was that the objective approach is when it's that as soon as the plaintiff puts a sues or puts a case for divorce, that's when they allowed to get the divorce. It's then the objective approach, and then the subjective would then, when the court takes into consideration its own interpretation of what's actually happening in the marriage. And then there was also something I didn't understand. So I'm just checking quickly about section 4 and 5, and then there was section 4, section 3, where I think it was
Okay,
saying
Cynthia.
that.
Okay, Cynthia, I really, can you please send your question either on the email or on the chat, because there was background noise. I think you are in the office, so I could not hear you at all. And I see from the chat there are others who are also saying they cannot hear you. Please write on the chat. Right. Okay. Thank you for that. Godfrey.
Hello, ma'am. It's
Yes,
Brunello.
hello, ma'am.
Okay.
It's
Okay.
Godfrey.
Wait. Okay, Winello will come back to you. Let's hear Godfrey, then we'll come into Winello. Godfrey?
Yes, I just wanted to ask if an abusive marriage can also be added on the example of irretrievable breakdown of a marriage.
Yes, it's one of the good examples of that. Because remember, as I always say, as I have been saying, that the court will not force anybody to continue with a marriage that they do not want to. They will not force a spouse to continue with a marriage where there is abuse. Abuse is one of the ground for irretrievable breakdown of a marriage. Thank you for your question. Quinello?
Thank you very much, ma'am, for giving me an opportunity. My question is, if, say, for instance, people got married a long time ago, before the marriages were registered on the system, right? Like maybe, say, 1982, 1980, bani, before they could register the marriage. And then these people maybe separated but didn't divorce, separated before they could update their marriage on the system. And then one of the spouses decided to get married to someone else later on, without divorcing from the person, from the first wife or the first husband. The second marriage, would the second marriage be recognized?
Okay. Firstly, the spouse who alleges that there is an existing marriage must bring a high court application to prove that the marriage was not dissolved. So the first thing is they need to prove that they entered into a marriage. So if it was those marriages, long marriages where there were not marriage certificate, and when the law now, or the policies now allowed for spouses to come and do late registration, and they did not use that opportunity, they must apply, they must bring a high court application to prove that they are in an existing marriage. Once they have proven that, the second aspect, they need to prove that the marriage was not terminated, it is still in existence. If they succeed on these two grounds, then the subsequent marriage is going to be declared null and void. Your example is what is currently happening now in many matters, but involving unregistered customary marriages and subsequent marriages where a spouse entered into a civil marriage with another spouse. So the first spouse, let's assume, is the one who was married in 1993, and there was no marriage certificate. As long as they can prove that they entered into a valid marriage and it was not terminated, then the subsequent civil the civil marriage is going to be declared null and void.
Okay, no, I understand. Ma'am, I have another
Okay.
question. My second question is, if say, for instance, people are married in community of property, they have a civil marriage, and then the husband, for instance, wants to take a second wife, would they have to dissolve the civil marriage? And I don't understand, would they have to dissolve the first marriage and maybe marry customarily, or how does that work?
Okay, civil marriages are monogamous. In other words, they are monogamous and they are heterosexual. So it can only be between a man and a woman. So if a husband in South Africa, only men are allowed to take more than one wife or more than one spouse. So if a husband wants to enter into a further marriage and have polygamy, the civil marriage must be terminated through divorce. It must be terminated through divorce, and the husband must marry all the women through customary law processes. That is when then he's going to have polygamy.
Okay. No, thank you very much.
Thank you. Let's hear from Lisa. Lisa, is your hand up? Lisa?
Yes, ma'am. Can you hear me?
Okay. Yes, I can hear you.
Yes. All right. Yes. So I just wanted to find out something. Am I correct to assume or to conclude rather that when it comes to the irretrievable breakdown of a marriage, because it's a bit of a hearsay from what everyone is discussing and what we're discussing now in the class and what we're learning, am I correct to then conclude that in these matters or matters relating to irretrievable breakdown of a marriage, the case must be proven on a balance of probabilities rather than beyond reasonable doubt?
Yes, it must be proven on a balance of probabilities. And the other thing is, you just round your ground on the pleadings. The divorce processes now, we've got what we call contested divorce and uncontested divorce. Uncontested divorce is when the parties enter into a settlement. Most of the time, they enter into a settlement agreement where they decide on their own how they're gonna divide their matrimonial estates, and they write the grounds on the summons. Contested divorce, it can be on two ways, matters. Firstly, one of the parties can contest that the marriage has not irretrievably broken down, but because the other party can either convince the court, or even if they don't convince the court, because it cannot force them to continue in a marriage that they do not want to be part of, can grant them a divorce on that matter. In other words, the irretrievable breakdown ground is that they no longer have love, they no longer have respect, there is no longer good communication between the two parties. And the other ground for contested is when the parties have been able to prove, when the parties have been able to prove that the marriage has irretrievably broken down, but they are not in agreement regarding division of their matrimonial estate, which is something that we're going to talk about in the next session. So that is what, but you are correct. It's on the balance of probabilities, and it's just something that it is written down on the pleadings, in the summons, and the court. Most of the time, especially the regional court, which now have the power to also terminate the marriage, they just take what is written on the pleadings. Thank you for that, Lisa. Okay, Tobile.
Can you hear me, ma'am?
Yes, you can ask Tobile.
Okay, thank you so much, ma'am. What I wanted to find out, in cases of the settlement, for the divorce, when the parties are married in community of property, I have a scenario here where the wife, during the proceedings of the divorce, she resigned from her job just so to keep her pension money to herself. And then the conditions that she has put on the settlement is that the matrimonial house that they shared with the ex-husband and the kids, it must be transferred to her name. And she wanted to take the husband's car because it's an expensive car. But at the very same time, she did not want to share any of her assets as per the rules of of each spouse getting 50-50 when they are married in community of property. So does the law not protect such people? Because when it looks like this settlement is just serving the one party, which is the ex-wife in this case, what are the recourses that are allowed in terms of the law to prevent such party taking advantage? Because the husband in this case is desperate to get the divorce settled as soon as possible, but I also feel he's getting the short end of the stick. Thanks.
Okay, remember, as I said, settlement agreements are in an uncontested divorce. Your scenario is such that this divorce proceeding has to be contested because there are, for example, the pension. You say the wife has withdrawn their pension, so the husband can contest that I want my 50% share of the pension, and also when it comes to division of the joint estate, I want my fair division, my fair share of the 50%. If the husband is desperate, unfortunately, that desperation is the one that is gonna lead him to make decisions that in the end will seem unfair to him. But if he voluntarily enters into a settlement agreement and signs and say, I agree that this is how the matrimonial estate is going to be divided, then he has himself to blame and nobody else, because the law or the court do not force spouses to enter into settlement agreements. As I said, there is an option of saying, I am not in agreement with this. Let this divorce proceedings now be contested. Okay.
Thank you so much, ma'am.
Okay, thank you. I just want to say, because I see now it's 11:05, I just want to say the three reasons besides irretrievable breakdown of the marriage. Secondly is incurable mental illness and continuous unconsciousness, and is incurable, is irretrievable breakdown of the marriage. That is number one. Number two is incurable mental illness, and the third one is continuous unconsciousness. It is important that you know these three reasons, especially the irretrievable breakdown of the marriage. It's also important that you know the court's discretion to refuse a divorce. As I said, the court does not necessarily have the discretion to refuse to grant a divorce order, with the exception of Section 5A of the Divorce Act. Students, I'm sorry that I could not take all of your questions. I see that we still have others who want to ask further questions. Please, if you want to talk to me, feel free to send me an email. Last week, I received quite a whole lot of emails. So if I have not responded back to you, can I please ask that you resend me the email? Just resend me the email so that I make sure that I do not miss anybody. My email address is monaring, monarkn@unisa.ac.za. Thank you for joining today's session. We will meet again next week, where we continue again with the topic of divorce. Please read. I will send a notice on the announcement. Please just make sure that you prepare for next week's session. Thank you so much and have a good day ahead. Thank you.
Thank you, ma'am.
Bye-bye.
Thank you, ma'am.
That was very productive. Bye, Mbulawa.
Thank you,
Bye.
ma'am.
Bye.
Bye, students.
Bye.